At 8:17 on a Monday morning, an employer withdrew a signed job offer because the applicant still could not provide acceptable proof of resident status. That week, the landlord ended the lease. A non-refundable flight was lost, and every month rent continued to leave the bank account, while the application seemed to disappear into silence. The question posted in an expat form was painfully simple. Can Portugal be made to pay? Sometimes there may be a compensation case, but not because the story is heartbreaking and not because every delay is unlawful. A case depends on proof, what the authority did or failed to do, what duty may have applied, what loss followed, and whether the loss can actually be connected to that conduct. Welcome to Portugal Rights Rebel, Episode 1. I'm Elena Vargas. Today, we tackle one of the most common nightmares expats face in Portugal and show you exactly how to fight back legally and effectively. We are not going to promise a payout or encourage a rushed lawsuit. We are going to build a compensation evidence ledger, a clear record that helps a qualified Portuguese lawyer test whether your losses may be legally recoverable and what should happen next. My position is simple. Before you escalate, build the proof. Outrage may start a complaint. A dated ledger is what lets a lawyer examine a compensation claim. Your rights don't disappear at the border. Let's slow down and separate the ideas people often blend together. There is a delay. There may be an error, omission, or failure of service. There may be unlawful conduct. Then there is damage, and there is causation, the link between the conduct and the damage. A lawyer may also need to examine fault, the applicable duty, the responsible authority, and whether the relevant procedure was followed. Here is the important distinction. A loss can be real, expensive, and deeply upsetting, yet still be difficult to prove as legally recoverable. Losing work while waiting for a residence document is serious, but was there a definite offer? Did the employer say the missing document caused the withdrawal? Would the position probably have continued? Did the authority have a duty to act by a particular date? That is not an attempt to minimize your experience. It is the beginning of a usable analysis. The system is slow. Your preparation shouldn't be.
For general orientation, Portugal State Civil Liability Framework is commonly discussed through Law 67/2007 concerning civil liability arising from public administrative activity. Administrative procedure also involves principles such as legality, impartiality, proportionality, good administration, and the duty to decide within the applicable rules. Constitutional protections may matter. In some cases, European Union law may matter too.
But legal names are not magic words. Saying Law 67/2007 does not automatically turn an AIMA delay into a damages award. The answer can depend on your application, the authority involved, the dates, the communications, the conduct alleged, and the remedy you want. An EU law argument should identify a specific right, directive, regulation, or effective remedy principle. It should not be added simply because the domestic process feels unfair. So ask a lawyer to identify the exact legal basis, the possible defendant or defendants, the competent procedure or court, and the deadlines. Verify current law before acting. This episode gives you a preparation method, not a legal opinion. Now, make the record. Use a spreadsheet, notebook, or secure document. Create one row for every meaningful event. Do not write one dramatic paragraph covering an entire year. Give each event its own date, authority, action or silence, and consequence. You write, AIMA delayed me. That is a conclusion, not yet an evidence entry. Try this instead. May 12th, application submitted and fee paid. June 3, requested document uploaded. July 18th, no decision, appointment, or explanation received. Attach the submission confirmation, the payment record, and the unanswered correspondence. That difference matters. A lawyer can test dates. A lawyer can compare the authority's conduct with the duty that may have applied. A lawyer can ask whether the delay crossed a legally important threshold. They ignored me expresses frustration. I sent this request on this date, followed up twice, and received no response before this documented loss gives the file something to examine. Your columns can remain simple: date, authority, action or silence, expected duty, actual consequence, amount, supporting proof, mitigation, and next step. Add a column for uncertainty. Mark an amount as paid, estimated, disputed, or still being calculated. Precision includes admitting what you do not yet know. Keep different kinds of harm separate. Direct financial losses might include documented extra accommodation, a non-refundable flight, translation fees, or reasonable professional expenses connected to the problem. Lost opportunities might include employment, a contract, or business activity, but those usually require stronger proof of probability and value. Non-pecuniary harm can involve anxiety, disruption, or family impact, subject to the legal standards that apply. Do not count one loss twice under different headings. Evidence should let a stranger understand the story without guessing. Preserve application confirmations, appointment notices, payment receipts, portal screenshots, emails, registered letters, and call records. Keep contracts, bank statements, invoices, employer letters, travel records, and housing notices when they relate to the claimed loss. If health information is relevant, collect only what is necessary and ask counsel how it should be handled. Rename files with the date and a short description. Keep the original where possible. Create a secure, read-only copy. A folder full of screenshots called Final New is not a legal strategy. If the stranger has to guess, the file is not ready. The hardest part is often causation, and this is where many claims go wrong. A loss can be real, costly, and still not be legally caused by the delay. Ask the counterfactual question: what would probably have happened if the authority had acted lawfully and within the relevant time frame? Imagine a conditional job offer. The employer says the residence document was needed, but the company later eliminates the position for unrelated economic reasons. The missing document may not be the cause of the lost income. Now, change the facts. The employer writes that the position remained available, that every other condition was satisfied, and that the offer was withdrawn only because acceptable proof did not arrive by a specified date. That is a much stronger piece of evidence. Mitigation belongs in the ledger, too. Record what you did to reduce the loss. Did you request clarification? Seek another appointment? Ask the employer for more time? Change travel plans? Find cheaper temporary housing? A compensation analysis may consider whether reasonable steps were available, so show both the problem and your response to it. Consider two anonymized files. In the first, the applicant has a documented submission, repeated unanswered messages, a housing termination notice, bank records showing €1,450 in temporary rent over 3 months, and a €320 non-refundable flight. An employer letter dated September 6th says the position remained available but was withdrawn because the unresolved status could not be accepted. The applicant also records efforts to reduce accommodation costs. That file does not guarantee success. It does give counsel specific events, amounts, documents, and a possible causal chain to investigate. The lawyer can challenge it, strengthen it, or explain where it fails. That is what a merits assessment is supposed to do. The second person lists €12,000 for stress, missed business, future income, and general inconvenience. There are no dated records, no employer confirmation, no invoices, and no explanation of what would probably have happened without the delay. The anger is understandable. The claim is not yet usable. What changed the legal assessment was not the intensity of the story. It was the quality of the proof. the realistic calculation and the connection between the alleged failure and the measurable consequence. Before contacting counsel, prepare a one-page summary. Put the application type at the top. Then list the key dates, the authority involved, the action or silence you are concerned about, the losses, the evidence you already have, and the steps you took to limit the damage. Keep the summary factual. Avoid accusations, speculation, and a dramatic estimate that the documents cannot support. At the end of that page, ask 3 questions. What is the strongest causal link? Which limitation periods or procedural risks apply? And what remedy is realistically available? You can add a 4th, what evidence would change your assessment? A good first meeting should help you understand not only why you might have a case, but why you might not. Look for a Portuguese lawyer with relevant experience in administrative litigation and public authority liability, not merely someone promising a fast result. Ask whether they handle immigration matters, damages claims, or both. Request a written assessment covering merits, evidence gaps, possible defendants, procedural routes, limitation periods, costs, and realistic outcomes. A careful lawyer may give you more questions than certainty at the first meeting. That is often a good sign. There may be several possible paths, and they are not interchangeable. A formal complaint can create a record and request action, but it may not compensate every loss. An administrative appeal may challenge a decision. A court action may involve different requirements, costs, and deadlines. A damages claim may need to be coordinated with the underlying immigration or administrative matter. Do not file impulsively because a template appears online. Do not assume the agency, the state, or an individual official is automatically the correct defendant. Do not let a public complaint replace urgent legal advice about a deadline. The right sequence depends on your facts, and a badly chosen procedure can waste time or complicate your position. Protect the evidence while you build it. Redact unnecessary passport numbers, addresses, bank details, and health information before sharing documents. Use encrypted storage when possible, and limit access to people who need it. Do not publish accusations about named officials or private individuals while the facts are being reviewed. And do not secretly record conversations without understanding the applicable Portuguese rules and possible consequences. Do not inflate the amount because the situation feels unfair. Do not merge every immigration problem, employment problem, contract dispute, and public liability theory into one emotional narrative. Keep the facts connected, but distinct enough for counsel to analyze each issue. Most importantly, do not miss a deadline while waiting for a perfect file. Ask a lawyer what must be done now and what evidence can follow later. Please hear this clearly. This episode is general educational information, not legal advice. Laws, limitation periods, courts, evidence rules, responsible parties, and available remedies can change. Your nationality, application type, documents, dates, and the authority involved may alter the analysis. Consult a qualified Portuguese lawyer before filing a compensation claim, signing a settlement, disclosing sensitive records, or relying on an EU law argument. Before this episode ends, open a note, spreadsheet, or secure file and write just 3 entries: the date, what the authority did or failed to do, the loss you can prove today. Tomorrow, add the documents. This week, turn the entries into a 1-page summary for a qualified lawyer. If you have the energy, continue until you reach 10 dated events: the application, payment, appointment, document request, unanswered message, canceled trip, lost work opportunity, extra housing cost, formal complaint, or another event you can support. Mark uncertain amounts as estimates. Note what you did to reduce the loss. Save the original securely, then preserve a read-only copy. This is the point of the ledger. It does not manufacture a case. It reveals the case you may have, the gaps you need to address, and the claims you should probably stop making. The anger may be justified, but proof is what turns a complaint into something a professional can evaluate. Turn bureaucracy into accountability. Knowledge is your best defense. Document everything, act lawfully, and protect your future. Always consult a qualified Portuguese lawyer for your specific case. If this episode helped you, share it with an expat, applicant, family, or business owner facing an unexplained administrative delay. And subscribe for practical guidance on protecting your rights in Portugal. Your rights don't disappear at the border.